Hi, good afternoon, everybody. My name is Chris Justice. I'm an employment lawyer, as you see there below, with Samfiru Tumarkin LLP, and I myself am working out of the firm's Toronto offices. But I'm here today, as I have been before, to hopefully answer as many of your questions as I can, all things employment law related. So whether it's something you may have a question about going into a job, or maybe there's something going on during the job itself, or possibly you've been let go and you've got some questions on your way out as far as next steps from there. As I say, get your questions in today, and I'll do my best to answer as many as I can, as I usually do. But also, as I usually do, I'd like to start off with a couple of topics that have been sort of trending in the news. The first of which has to do actually with a number of people being let go from their jobs, which we've seen a lot as of recent days. A lot of industries are cutting jobs, reducing costs, and this is resulting in a lot of terminations across several different industries. The particular story I was going to talk about today in this sense had to do with a company by the name of Vice Media Group, who are eliminating hundreds of jobs under what they call sort of an overall restructuring or reorganization. And normally speaking, companies can let people go for any reason they want, as long as it's not outright discrimination or something that's extreme bad faith. But a restructuring or a reorganization, often phrases people hear, assuming that's true, then again, that's perfectly reasonable as being a basis for someone's termination. As I say, in Vice Media Group's case, a lot of people are being let go apparently due to this reorg or restructuring. Now, if you're in a position, you've been let go, frankly, whether it's with cause or without cause, you want to get a lawyer's advice before you sign any release or any document that your employer is asking you sign in order to get your full severance package. Because you may look at your package, like employees at Vice Media Group may look at their packages that they're being offered and think that, oh, the company is actually going above and beyond to give me not only what my bare minimum entitlements are, but they're throwing an extra month or 2 or 3 on top of that if I sign this full and final release. That to me seems like a fair package and I'll just sign off on it. Well, no, you'll definitely have to think twice on that, because even though you may look at a severance package, or these Vice Media Group employees may look at a severance package and think it's fair, 9 times out of 10, if not more, the package isn't fair. The package is well below what your actual and full entitlements are. And again, all the more reason why you need to make sure you're getting legal advice before you sign off on any package, no matter how good it seems to look from your perspective. In general, people can get upwards of 24, even 26 months of severance. And that has to do with things like how old they are when they've been let go, what their position is, what length of service they have with the company, and ultimately what else is out there that's available that would compare to what they had that they can go out and try to get. But all of these factors are sort of lumped in together. And like I say, there are scenarios where people get 2 years of severance, or maybe a year or a year and a half. Even short-term service employees, if you're being let go due to a reorganization or a restructuring, and you've only been at a company maybe for a year or 2, and you're thinking, well, I'm not owed that much. Well, there are cases where people with a year or 2 get 4, 5, 6, 7, 8 months, potentially even more than that. So even short-term service employees, don't necessarily discount yourselves too much and think that the package is fair in your case, because again, a lot of times you could be throwing away tens of thousands of dollars, if not more, unbeknownst to yourself. So that's kind of my general topic, just the first one anyways, off the top of today's show, just to do with people who get packaged out and making sure that you get your fair package, but getting legal advice before signing off. There's another news story that was coming up in the news that had to do with a purchase and sale. In this case, BuzzFeed is eliminating about 16% of its staff and selling a portion, at least, of the business to Complex, another company. A lot of times people work for a company that ends up getting bought out by another, and they wonder, how does this affect my situation? How does this affect my rights? Now, if you work for one company and another company buys you out and your job just continues seamlessly, then in all likelihood, you're just going to be seen as someone with all that seniority, and then added on to the second portion with the purchaser of the business, that seniority will generally carry over. And if you're ever let go from the purchaser or the new employer, the employer has to consider not just your service with them, but your service with the prior company as well. But there are situations where you are not hired on with the new company and where you're let go. And in that case, typically you're going to want to get your full severance from the person who let you go, the seller of the business, because you never actually worked for the buyer. You never worked for the new company. So if your employment is not being continued as a result of that purchase and sale, then your severance entitlements would generally be the same as if you were let go due to a reorganization or restructuring, as I mentioned at the top of today's show. But sometimes you are an employee at one company and they get bought out by another company. And then you are asked before you can start with the new company to actually sign an employment agreement, maybe a different type of a contract that the buyer wants you to sign. And again, before you sign anything, get legal advice, especially if you're in a situation like this. A lot of times someone may be with a company for 10, 15, 20 years, and then their company gets bought out. They then end up being told or asked to sign a contract. They think nothing of it. They're just told that it's just the new company papering their trail. So they sign this contract 10, 15, 20 years in, and then they get let go by the company that purchased the business maybe a year or two later, and then find out that this contract they signed ends up basically screwing them out of their full and complete severance entitlements. So again, all the more reason why you want to make sure, no matter who you are, what situation you're in, if you're being confronted or being asked to sign a document, something's being put in front of you, definitely give us a shout, because in a purchase and sale situation, you may not have had a contract that with the first company that sold the business, and your severance entitlements at that point could have been upwards of 2 years. But by virtue of signing this new contract, you're now limiting yourself greatly. So just bear that in mind, keep that in mind. And if you're someone in a situation where your employer's been bought out by another company and you're wondering maybe how much severance you're owed or whether you have any obligation to stick on board with the new company, give us a shout and we'll kind of talk you through that whole process. I'll get into some more topics that I had off the top, but I want to get into some of the questions first. And the first question comes from Sir on YouTube, who's asking how effective demand letters are and whether arbitration is better than litigation. So usually when somebody approaches me, they've been let go, let's say, and they're wondering if they're owed more severance or not, and I tell them that they are owed more severance, usually the process starts by trying to resolve your case without the need for litigation whatsoever. And that's typically done first by way of an initial demand letter. And in that letter, the whole point is to try to resolve things amicably, obviously get more severance, but in the demand sort of list what severance you're looking for, what compensation you're looking for. And again, the goal being to resolve it within the somewhat near future and not resorting to litigation. And in a lot of cases, demand letters are very effective. In a good chunk of cases, maybe half, maybe even more than half, these cases are resolved without the need for any litigation whatsoever, and through just sending off a demand letter or maybe having a little bit of back and forth after that, but usually within 1, 2, maybe 3 months. Obviously, once you get into litigation, now you're looking at generally a longer time frame. And in a lot of situations, it just doesn't make practical sense to go through all that hassle, depending on where you're at by the time your demand letters have been sent off and you've received replies. So demand letters can be effective, not only in resolving things relatively quickly, but also even in getting people what they're fair and reasonably entitled to. So I would say that there is some effect to demand letters, and in probably most cases, it's going to make sense for you to try at least once to resolve the matter without resorting to litigation or arbitration. So litigation has its benefits as well. I mean, if you're going after the company for a larger sum of money such that it makes litigation worthwhile, especially when you consider how much time is factored into litigation, then litigation can be a perfectly reasonable step to take. Obviously, it's a step you want to try to avoid, but as I say, when the amount of dollars you're looking for is quite great, that can be that will often outweigh any costs or I guess extra time involved in litigation. Arbitration, on the other hand, first of all, arbitration is a phrase that more so comes up in the context of unionized labor disputes, something that we, or at least myself, I don't specialize in per se, but I do know that for a lot of unionized matters, under the collective bargaining agreement, there is a process that sets out maybe arbitration happening. And arbitration is in a lot of ways similar to a trial. You've got an arbitrator, someone who's typically there with the ability to make a binding judgment. And actually is as an alternative to going to trial, which can take 2, 3, 4 years in some cases. There are scenarios, even in the non-unionized context, where arbitration can be better than prolonged litigation. So usually arbitration is a feature of litigation, but it can happen before a trial and have the same outcome as a trial. So arbitration in some contexts can be good to just get some finality to your case and not necessarily have to wait as long as you typically would for a trial. But usually, again, the starting point is the demand letter, and that's probably the recommended choice for most people. I've got another question in from Sherry on YouTube, who's saying that they are secretly working 2 remote full-time jobs and wondering if this is illegal. They say that they know it breaches their contracts, but what are the chances of facing legal consequences or a lawsuit if discovered? So it's not illegal to work 2 full-time jobs. However, usually when you start a job, there is the expectation that especially a full-time job, that you're going to be committing your full time and efforts and attention towards. And there may even be a contract that you sign when you start a job that mentions sort of at the top or the first or second page, I so-and-so will devote my full time and attention to this job. And, your employer, I'm sure in a lot of these cases, is going to want to know whether you are working another job, because if you've got 2 full-time jobs going on, the problem, number one, is that you might actually be in violation of a contract you've signed, in which case your employer could let you go potentially for cause and not actually pay you any severance. Not always the case, and something you want to get a lawyer's advice on, but that's a possible outcome there. But also, just from a practical sense, putting the contract aside, are you able to do these 2 jobs, in full? Does the fact of you having 2 full-time jobs take away or affect your ability to do one job or the other? Is there a conflict of interest, for example, where you can't perform, both jobs at 100% because you're taking them both on? And again, that kind of goes towards a general expectation a lot of companies have when it comes to full-time jobs, whether it's something that you have in a contract or not. Usually disclosing that information is going to be beneficial to you, because if not, even if it's not in your contract, your employer finds out and also has evidence to show you're not, performing your job as well as you should be, then that could lead to a termination. There are scenarios where an employer finds out you have 2 jobs and lets you go without cause and maybe gives you some severance. Or, as I said before, there's some scenarios where an employer finds out you've got 2 jobs and they try to make the allegation that there's cause to terminate your employment. It's probably unlikely that your employer is going to pursue a lawsuit against you if they discover this, unless there's some bigger issue at play than just you splitting your time and efforts between 2 jobs. For example, maybe you work for 2 different jobs, employers of which compete with each other. Or maybe you use information gained at one job that might be confidential or proprietary to further yourself in the other job. And then you start to get into issues of confidentiality, and that might be more so where an employer brings a lawsuit if they feel as though they have now suffered damages in some respect as a result of you working these 2 jobs. That's probably the most likely way that a lawsuit would sort of materialize. But otherwise, I would say at the very least, your employment itself could be at jeopardy if they find out and you hadn't disclosed this, or it's in breach of a contract, or somehow affecting your job either way. I've got another question in from Sammy on YouTube, who's asking whether an employer can change remote work protocols whenever they want. They've been 3 days in the office for the last year, but they're now saying they have to do 4 days in the office. And Sammy, I would say, generally speaking, it's going to depend on whether there's, say, a contract or a policy that you've agreed to when it comes to remote work. So it could be the case that this change is a constructive dismissal, going from 3 days in the office to 4. But it could also be the case that the employer's expectations for someone to go in and do 4 days in the office is reasonable. And I'll give you maybe one example. So one example would be, let's say you join a company and from day one, you're working 3 days in the office, and your contract says that. It says that you will show up to the office 3 days a week. and the other 2 days or 3 days, whatever, you work from home. And let's just say from day one, this was the case, and you've been doing it for months, several years. And now all of a sudden they want you in for an extra day. There's going to be a better chance for you to say no and kind of draw a line in the sand and say, no, look, I agreed to 3 days, but not 4. I think that's a substantial change. But if you had been, let's say, working in the office 4 or 5 days for several months or several years, and then your employer, reduced it maybe to 3 days, but now they want to go back to 4, which they were doing maybe previously, then that might be a different scenario, because you wouldn't be an employee with a contract that specifically says, you can work for 2 or 3 days from home each week. It's more of a, you weren't working from home initially, and then they implemented something on a temporary basis, but now they're going back to how things were. Then you may not have as much leverage to draw a line in the sand or sort of say that that's not something you're agreeable to. So it will kind of come down case to case basis. The other thing I'll mention on this is, maybe you were working in the office 4 or 5 days a week in the past, but you don't want to do it now because, say, you've got childcare commitments or family commitments or some sort of accommodation need for wanting or being required to work from home. If that's the case and there's some sort of human rights element involved and you need that accommodation, then that's a scenario where your employer is going to have less leverage and they're going to have to generally try to accommodate you. And if they don't, then there could be a human rights violation. So that could kind of throw a little bit of a wrench into their plans, depending on what your situation involves. So there are a number of different ways, I guess, it could go, but it would depend on each case. And Sammy, I would just say, give us a shout. If anything, call our office. We could set up a time for a consultation, and we can kind of give you a sense of whether you have any leg to stand on. Can you just say no and insist that you only work 3 days in the office each week? Or does the employer have a bit more of a leg to stand on, maybe more leverage to say that it's reasonable for you to come in? But give us a shout, because before you get into sort of the nitty gritty and the communications with your employer, it'd be good to get some advice, and then we can kind of maybe talk you through how the best way to communicate would be. I've got another question in from Al Kareem, who's writing on YouTube, who's saying that they're 57, let go after 23 years of service for cause. They were loading a trailer and moved it off the shipping dock, and they were blamed for the error. But Al Kareem says that the driver, not himself, was the one responsible for the error. And Al Kareem's got a follow-up note just saying, different between examination and cross-examination. Do I have a case? Am I entitled to severance and back pay? So thanks for the question. First of all, if you've been working at a company for 23 years, you're 57, and you've been let go for alleged cause, there's a chance, maybe even a good chance, that your company does not have cause and that you're actually owed your full severance. And as a 23-year employee who's 57, you could get upwards of 2 years of severance. And I know a lot of cases where people with your length of service and your age, they get accused of cause. They get blamed for something cause related, and then they get let go, and then they basically get no severance on their way out. So even if there is a possibility that there might be cause, usually there's still a very good chance that there isn't. And for that reason, it makes sense for most employers to pay severance. In Al Kareem, in your case, I would say it makes sense for you to give us a shout ASAP, because your potential severance entitlements here could be very significant, even though your employer is saying that they have cause and that they're blaming you for certain things. If that's actually not true or not the case, or there's someone else who's at fault, then all of that information is going to go towards supporting your case and giving you a basis to go after that company for maybe upwards of 2 years of severance, if not, additional damages on top of that. I don't know if you're going to have to do a lawsuit or continue to fight this tooth and nail for a year or 2 or 3. That might be possible. But again, I'd like to at least find out if maybe a resolution is possible early on, perhaps through a demand letter, trying to resolve things more amicably. But I would definitely give us a call, Al Kareem, because it seems like there's that potential there, and we can kind of talk through the specifics about, what your case involves, and also the road ahead as far as if you do need to commence a lawsuit, what are you in for? What do you have to do? And maybe a rough timeline on what to expect. But thanks for your question. I've got another one in from Josh on YouTube, who's saying they had a demand letter sent to their ex-employer. They responded a few days later before the deadline and asked for an extension. Josh says that the employer or Josh agreed to their extension, but now they haven't responded. And Josh, this is unfortunately a relatively common occurrence where you will try and resolve your case through a demand letter. You put a deadline on your demand letter, but because you haven't actually commenced litigation or a lawsuit yet, there's no strict timelines that your employer, your ex-employer has to follow. And there are situations where I've sent demand letters and they've asked for an extension. I've said yes, and I still don't have a response. Now, depending on how much longer you have to wait after that, it may very well be in your interest to simply say, you know what, forget it. I tried resolving this by demand letter. They don't want to respond. So let's now go forward with the lawsuit. So that could be a very realistic possibility. And in cases I've had where I've been getting a non-response, I've spoken with my clients and I've said that, look, we can either wait around indefinitely and hope that we get a response, or we can go forward with the lawsuit. And then, like I say, in some cases it makes sense to go with the lawsuit. And in other cases, it makes sense to maybe wait a week or two more if we have to, maybe because there's other factors at play that could, eliminate the reasonableness of a lawsuit. So even though you may not be getting a response from your employer immediately, if they respond, let's say within the first month after your termination or your demand letter, it still might be worth it to try and negotiate someone, because once you go the lawsuit route, as I was saying earlier, you end up tend to getting locked into a bit lengthier of a process, which can be good, but it can also be counterproductive to your interests. So it sort of depends on, what you're looking for, how much money your employer offered, what the risks are generally in your case, and whether you're going to find a job in the near future. I mean, these are all things to consider when deciding, do I wait a bit longer for a response on my demand letter, or do I just say, enough's enough, let's go forward with the lawsuit? So it's hard to say for every case per se, but if anything, you want a second opinion, Josh, give us a shout, and I can probably give you an idea of kind of, whether you should wait, whether it makes sense, and if so, how long. I've got another question in from Ash on YouTube, who's asking whether there's certain jobs or sectors where a non-compete clause is allowed. If those of you don't know yet, back, I think it was in 2021, late 2021 or 22, a ban was actually placed on non-compete clauses within Ontario. And in general, there's not many, if any, exceptions to this, because employers simply courts, I should say, don't like it when employers put a restraint on someone's ability to go out and find another job after they've been let go. So if you're someone, frankly, across the board, industry-wise, that has a non-compete in their contract, the vast likelihood is that it's not going to be allowed. Now, if you have a contract that was maybe before the ban came into effect, say in Ontario, there may be a question on whether the non-compete clause in an older contract is allowed. But in general, even that's not allowed and hasn't been allowed historically. But it may technically come down to how the clause is worded, when the clause was given to you, in order for a lawyer to give you the proper advice. So Ash, I would say, give us a shout, let us know kind of what's your job or what sector you're in, send us a copy of the non-compete clause and kind of when that even came into play. And we'll be able to give you a more detailed answer as far as, if there's any concern whatsoever to this non-compete clause. I've got another question in from Christian on YouTube, who's asking whether or not they can sue both their former employer and WSIB and add punitive damages or for wrongful dismissal or termination after suffering multiple work-related accidents because of unsafe working conditions. Now, I can't comment on your ability to sue WSIB. As I understand, though, WSIB would kick in, of course, if you have suffered a work-related injury. Let's say that you are not able to work as a result. And, for example, WSIB would then provide loss of earning benefits or benefits to cover that period of time generally when you're not able to work. Now, if WSIB has not followed through with their obligation in a sense, if there has been some sort of breach on WSIB's part where, let's say, for instance, they deny you access to benefits or cut you off benefits that you are rightfully owed, then you could very well have a claim against WSIB. But as far as going after WSIB for suffering the work-related accidents themselves, that wouldn't be so much. But it is possible you could have a claim against WSIB. It just depends on what exactly is happening as far as them giving you benefits or not. As far as the former employer is concerned, though, if you have suffered multiple work-related accidents and it's because of unsafe working conditions and you've raised these conditions to the company's attention. So, for example, let's say you complain to your employer about unsafe working conditions, A, B, C, D, and your employer does nothing to address those unsafe working conditions, and you continue on your job and end up getting injured as a result when you have proof to show that you had made complaints, you had raised concerns and all that. Number one, your employer could be failing its duty to keep a safe and healthy work environment and could be in violation of the Occupational Health and Safety Act, for example. But if you've also been let go after having suffered multiple work-related accidents, then the other concern would be, have I been let go due to my injury? Have I been let go due to being off work, due to my need for accommodation? And then that's where you get into the whole can of worms against your former employer as far as punitive damages, as far as human rights related damages. Not only would your employer owe you a severance package in the event of the termination, but as I say, they could be on the hook for all these other types of damages, including, failure to accommodate, failure to keeping a safe workplace. So, Christian, it does seem like there's a lot going on in your case, and there could be a lot of potential on both the employer and WSIB side. And I would definitely recommend you give us a shout, take us through that information in more detail, and then we can give you a sense of kind of what your options are moving forward so that you're best informed as far as making that right decision. But thanks for your question. I've got another question, and actually it's a follow-up question from Sherry. Earlier, she was talking about having a remote job and the employer insisting that they come in 4 days a week to the office rather than 3. Sherry's saying that she began the remote job, I think, as a remote job, but the contract mentions travel requirements that she can't meet due to a medical condition, and she hasn't let her employer know. So I would say that in this case, if you've got a medical condition which is preventing you from doing what it is your employer is asking, and that condition can be accommodated by just having you remain working from home, which it seems like you've been doing to some extent ever since you began, then I don't see why there wouldn't be an obligation on your employer to accommodate that condition. I'm not sure how long the condition's lasting for, but I would get support from your doctor, because it comes from the doctor if you've got a GP or a specialist who can provide support as far as saying, this is a patient of mine, and they've got, certain restrictions or limitations that prevent them from traveling. You don't have to reveal a diagnosis or anything like that, but maybe just confirming what your restrictions or limitations are, and then confirming that accommodation is needed in the form of a work from home arrangement. Then in most cases, that employer is going to be obligated to accommodate. And so that's kind of how I would start. Now, if they deny you the accommodation, that's when we might get into a bit of a can of worms as far as their obligation to accommodate and whether they're failing in that obligation. But I'd start with getting the support from the doctor, setting out what it is your accommodation needs are without giving too much private information, absolutely, but setting that out at the very least. And then, submitting that to them as far as the accommodation request is concerned and seeing where to go from there. But this also might be a case where you want to give us a shout just to make sure that, T's are crossed, I's dotted, you're having all the right communications you need so that if your employer fails in its obligations, you've kind of papered your trail along the way to give yourself the best possibility of either accommodation or, God forbid, they don't accommodate you. You may have a much better ability to then go after them for things like your severance, for things like human rights damages, etc. I'll answer one more question. I apologize for those I didn't get to, but I'll answer one more before I go. And I've got one in from Shanae on YouTube who's saying asking whether or not there's any recourse available to them being unexpectedly let go with 1 week of severance pay, considering that they completed 1 year or would have completed 1 year of employment in April. So, Shanae, it's not unusual for that offer itself that you got to be 1 week. That would probably, it seems like, represent your bare minimum entitlements, but your potential maximum entitlements as far as severance is concerned, even though you were there for just upwards of a year, I could see you getting potentially 3, 4, 5, 6 months of severance, depending on your position, your age, and everything else. So I would get in touch with us. I would set up a consultation with us and kind of go through your situation, because there could be more there for you to gain, even though you were there for a relatively short period of time. And I see here you had a follow-up comment about the work environment being very toxic. So that could just even add more to the situation and make it even more worthwhile for you to pursue. So give us a shout. Thanks again, though, everyone, for their questions. Shanae, you're asking how much a consultation is. By the way, we can do free consultations depending on your situation. So I'd say start by giving us a shout. We'll then have our intake team assess your case, determine whether or not we can offer, say, a free consultation or a paid consultation, but at least go that much and see where we go from there. And hopefully we can help you out. But again, I thank everyone for their time today. Thanks for the questions. Hopefully you enjoyed today's session. We've got sessions going on all the time. You see down below there, as far as disability law is concerned, we've got Martin tomorrow. So if you've got disability related questions, maybe you've been denied LTD, you've denied short-term disability, you've got an issue with your insurer, Martin will be on hand to answer all those questions and more. And we also have another employment law Q&A. If you've got more employment questions, that's with Mr. Leo Samfiru himself, February 28th at 1 o'clock Eastern. So tune in then if you want your questions answered. And thanks again, everyone, for your time. All the best for the rest of the day. Do take care. Bye for now.